we're now joined by former Attorney General of the Federation and Minister of Justice, Michael Aondoakaa. He will speak on the matters arising from last Friday's judgment, especially on the Kano and Plateau State election disputes and the lambasting of the Court of Appeal for indulging in the miscarriage of justice. He will also be discussing the legal remedy available to PDP and its lawmakers, whose Monday the Court of Appeal dashed away to APC rivals. Good afternoon and welcome to Arise News. Thank you so much for joining us on Newsday.
Good afternoon. Happy New Year.
Happy New Year. Now, I would like you to give your opinion, on the Supreme Court's decision affirming the election of 8 state governors, especially when the appeal court had overturned some of them earlier.
Well, thank you very much. First, that is the reason why we call the Supreme Court Supreme Court. Because it's the last hope of every person, the common man and every person in Nigeria. They seem to be very thorough to ensure that there's no miscarriage of justice. The essence of the Supreme Court of every country is ensure that there's no miscarriage of justice. And that is exactly what the Supreme Court did in the cases, the 8 cases. It looked at it passionately and was able to ensure that there was no miscarriage of justice. And I think that was a very happy development. Being the highest court of law, it has created a precedent. The doctrine of stare decisis, it means subsequent cases that are arising of this nature, the lower courts will be bound to follow the decisions of the Supreme Court.
Now, while ruling on the Plateau State governorship election, the Supreme Court said the election tribunal had no jurisdiction and, of course, the appeal court, to determine the validity of the primary election conducted by the PDP. One of the judges even said that the Supreme Court had said that, repeatedly. So in this instance, is there any remedy for the PDP lawmakers who were recently sacked by the Court of Appeal, saying as their own case terminates at the Court of Appeal?
Well, I'm confused, just like any other person would be confused. If you follow the most classical decisions of Mark IV, which if a judgment is a nullity. Imagine if you give a judgment with lack of jurisdiction, it's a nullity. And the court that gave that judgment has a right and inherent jurisdiction to set aside the judgment that is a nullity. I think the appropriate thing is with the Supreme Court decision that says they have no jurisdiction, the appropriate thing is for the Plateau lawmakers to go back to the Court of Appeal, use a judgment of the Supreme Court, and say, look, you had no jurisdiction. And therefore, your judgment was a nullity, set it aside. I think that is the most appropriate thing. They can try that aspect. Certainly, they don't have a remedy of going to Supreme Court because the Court of Appeal is the last court of the land. And that is the circumstances where Supreme Court said the judgment in, it was a criminal matter. Supreme Court's the judgment in the Ojikalo's case. It was not Ojikalo that went to court, but the whole judgment was declared a nullity for want of jurisdiction. This one, it was relating to the person adjudicating, because the justice that gave the judgment at the trial court was already a judge of the Court of Appeal. And because the judgment was a nullity, the conviction of Ojikalo was set aside by the High Court. They went back to the High Court. I said, look, the Supreme Court have declared this judgment a nullity, so set it aside. And I believe the lawmakers in Plateau, now that the Supreme Court has come heavily to say, look, there was no jurisdiction by the tribunal. There was also no jurisdiction but a court of appeal to entertain the matter, and issues that, like on jurisdiction, goes to a very serious issue. And therefore, which means, like on jurisdiction, means their judgment was a nullity. And I think the House of Assembly members, indeed, including the senator that was removed, can go back and file an application at the court. The only problem we have now is the time bound. The time bound. Ordinary, if we win ordinary civil matters that can go back and say the judgment is a nullity, set it aside. But there's a time-bound situation here, which is constitutional. That is where they may have a bottleneck. And that is it's a very difficult and sad scenario. Because constitutionally, everything has to end and time has abated. There's nothing anybody can do about it. Maybe the judgments of the Supreme Court will be a guide, a future guide. The option of ordinary, if it were a civil matter, they would have gone back to the Court of Appeal to set aside the judgment because it's a nullity. But time issue, being constitutionally 180 days, having lapsed, there's nothing anybody can do about it.
No, we wouldn't
that
have
is
gotten,
my opinion.
Well, thank you so much for giving us your opinion, but to an outsider, looking in, it wouldn't have gotten to this case if the Court of Appeal had just respected judicial precedents. So what can be done, regarding this? How do we ensure that the lower courts respect judicial precedents? Is this something that the National Judicial Council can look into?
There are several options that this matter can be handled. It can be judicial education, judicial discipline, a lot of other issues can be done. Maybe after the judgments of the electoral processes, they should need for a seminar so that we can digest these judgments and see where certain justices, whether Court of Appeal or tribunal, completely ignored positions of Supreme Court. And maybe they will be well educated on it. You see, judges have kind of judicial immunity. If you hear a judge err in law, that does not amount to a matter that will go to NJC. At that point, that is the highest limit of his understanding. There's no deliberate intention to create mischief, except the person going to NG will establish that it was done deliberately, maliciously, and I don't see any malice. At that point, that was their own understanding. They may be tempted to look at the case that affected Zamfara some other time to give that interpretation. But you see, this was in Plateau, it involved congresses, or who had the authority to conduct congresses. That couldn't have come to play in an election, post-election matter. But unfortunately, they must have read the judgments of the Supreme Court in Zamfara matter, and they try to make it look like that is the same scenario. So that creates, it's simply a matter of education. Issue of NJC will not fly in the sense that they didn't deliberately. There's no evidence to show that they deliberately acted malefice. Therefore, I would suggest, like the president of the Court of Appeal, we have to sit down with the judges in a seminar, like 3-4 days, try to harmonize and make sure that there's uniformity in the decisions of the Court of Appeal in various divisions. We are having that problems where there's a lot of conflicting decisions on the same subject matter arising from different divisions of the Court of Appeal. There must be a way that they will harmonize this. to create some kind of sense. Because Court of Appeal decisions are supposed to have binding force until they are set aside on the lower courts and tribunals established by law. And therefore, where there appear to be so conflicting judgment of the Court of Appeal on the same subject matter, and then in electoral matter, Court of Appeal being the final court in elections relating to Senate, House or Assembly, House of Reps, it's something very serious for them to have a second look at it. Because voters, when the judge sits in an electoral matter, it is not a case between the parties. The judges have to go beyond the case between the parties that have gone to court, but to look at the protection and justice to the electors, those who voted for or and against those people in the court. It is very sad for somebody who has gone to vote and ensure that somebody is voted for, and then he is being thrown out of the State House or Assembly on grounds other than grounds valid in law, because the Supreme Court now is saying it's not valid in law. Then there's a bottleneck because the constitutional provision is there. You cannot go back because 880 days have expired. Even you cannot, so it's a very, very difficult situation that I will expect the President of the Court of Appeal, and indeed even the Chief Justice of Nigeria, through a judicial education, to look at it and address it and talk to themselves so that there will be harmony. But clearly it's not an NJSC matter, because there's no evidence to show that the judges were under undue influence.
Now, while some people argue, that not all post-election cases should be taken to the Supreme Court, some are suggesting perhaps that the law should be changed, considering the miscarriage of justice that happened at the Court of Appeal. What are your thoughts on this? Should more cases be allowed to get to the Supreme Court?
Well, the issue is not an issue of more cases being allowed, but the issue is when the matter of governors going to Supreme Court came, it was because of this miscarriage of justice that Supreme Court felt governor of a state controlling a big territory being voted for, and we are practicing a federation, and such gross miscarriage of justice will occur and there will be no remedy. There was a likelihood of lack of public confidence. And that's the reason the Supreme Court and the National Assembly, in their wisdom, say, okay, let us allow governors to go to Supreme Court. But we cannot say because of this, House of Assembly, House of Reps, House of Assembly, House of Reps, and all of them should go to Supreme Court. That may create more chaos and overwhelm the Supreme Court itself. What is needed is the discipline of the judges itself. Discipline not through NJSC, discipline through their continuous education, and if they have this type of crisis situation, they should sit together and see how the subsequent elections or by-election being ordered, they will address it. That should be a more better suggestion.
Now, the Kano State Governor, in a statement, said
I will not support.
Okay, can I go on with my question?
Yes, go ahead.
Now, the Kano State Governor, in a statement, said that the APC chairman and former governor of Kano State, Abdullahi Ganduje, pressured the president to influence the court's verdict, but that the president did not yield to the pressure. And of course, after the Supreme Court ruling, we saw a lot of the governors, thanking the president for taking a neutral stance. What does this say about our judicial process, where it seems that external parties can influence its decisions whenever they wish to?
You see, politicians will not want to give credit where it is due. This was a pure judicial matter. Dragging the president into it is unfortunate. President is not expected to interfere into judicial process. And I don't think the president do interfere. Even during my time, we never interfered. We have elections from other, I think Ondo was my party, PDP then, but we lost. In Ondo, Labour won. Presidency is not expected to interfere. Those even talking about president, thanking the president, not interfering, they're eroding public confidence in the judiciary. They are trying to bring a dimension that is very unfortunate. They are even doing the president disservice. They are trying to create an impression that the president chooses which one to have favorable judgment, which I think President Ahmed Tinubu cannot be a party to that type of thing. He's a true Democrat who fought for it, even during the military. So I think those people should reframe on the thanking the president. If they want to thank, they should thank the judges of the Supreme Court, who in their wisdom, within the shortest time, felt that it is better to follow the law without undue influence and give judgment in such a way. Supreme Court, apart from the fact that it's the highest court of law, it's also the high court of judicial policy. It's also a court of policy. You saw a situation where everything was sliding to a one-party state. If those judgments were if there's nothing came from the Supreme Court, Nigeria would have been heading for a one-party state. And that is not even what the president will desire. Because during the President Obasanjo period, the president now was able to survive and was able to ensure that the political parties other than PDP won elections. So how can the same president interfere? So bringing the presidency in order to create tension within local politics does not fly. I don't think there's any evidence that the president spoke to the Court of Appeal, the judges of the Supreme Court. And the judges of the Supreme Court that I know them are the highest people of integrity. Throughout these periods, I don't think any of the judges want to have any contact with the Supreme Court, with the presidency. So I feel very sad as former Attorney General.
Well, Mr. Michael Aondoakaa, former Attorney General of the Federation and Minister of Justice, we've come to the end of this interview. It's been a delight speaking with you. Thank you so much for talking to us on Newsday.